Quickly run through the agenda for the day. We have first a few minutes from me. I'm Arpinder Singh. I work in Ernst Young. Then we have followed with a keynote address on the impact of changes in arbitration by the Hon'ble Justice Srikrishna, sir, who's sitting here, the former judge at the Supreme Court of India, and I think we're very honored to have him. And then we are followed by Karishma Vora, who's a barrister at 45 Gray's Inn Square in London. And she's going to conduct a session on exiting joint ventures and private equity investments and issues related to potential breach of contract. To do a quick introduction, I think he doesn't need any introduction, but I'll still speak for 2 minutes. So Justice Srikrishna was obviously enrolled as an advocate back in 1962 in the Mumbai High Court. He was designated as a senior advocate in June 1987 and an additional judge of the Bombay High Court in 1990. But really, I think, sir, we heard a lot about him was during the riots and the Srikrishna Commission, which happened in 1992-93, and obviously the report was submitted in 1998. September 2001 was when Justice Srikrishna was appointed as the Chief Justice of the Kerala High Court, and in 2002 as the Judge of the Supreme Court, and then he retired in 2006. But I think I've seen him so active in the arbitration and other forums, etc., and I think it would be a pleasure to hear him today. So I would request you if all of you can welcome him.
That being an optimist, I share your optimism, but being a practical person, I see on the ground level that much of what is touted for the benefit of people in this country and abroad is not really happening on the ground level. There are several reasons for it. Actually, arbitration is supposed to be an alternative dispute remedy. But what has happened is, in practice, it has added one more layer of litigation. The idea of arbitration is that in an informal atmosphere, probably like this, people sit around the table, round or rectangular, thrash out their disputes informally, and arrive at a solution which will be acceptable and implemented so that time is saved, money is saved, energies are saved. What do we see in practice is that at great expense of time, energy and money, an award is produced and then immediately it is challenged in the High Court. Thereafter there is an appeal, thereafter there is a litigation in the Supreme Court. So what have we done? All these were originally there. You have just added one more layer to the litigation. Now why does it happen? It happens because the mindset has not changed. The mindset of an average litigant in India is that somehow or the other I must succeed. There is no grace in accepting and saying, okay, we couldn't see eye to eye and agree on an issue. Let a third party, neutral chap who has nothing to do with this dispute say something, we'll accept. Perhaps that was what was there in the panchayats that we hear, not the Khap panchayats, the other panchayats that we have in the villages. They accepted it. That attitude is not displayed at all at the lower level. And finally, the mindset of the judges hasn't changed. A judge will hear a petition under Section 34 of the Act as if he is hearing a first appeal and saying, oh, this was not carefully considered by the arbitrator, therefore I must interfere. That is not the role of a court under Section 34. Section 34 only gives limited processual challenge to an arbitration award, either on the ground that the arbitrator is biased or that there is some fundamental flaw in it. Now, we had in India 2 arbitration awards, right from the 1940 award. The 1940 Act had its own peculiar provisions, and a famous judge of the Supreme Court of India raised a quip and said that the Arbitration Act left the litigant crying and the arbitrator smiling all the way to the lawyer smiling all the way to the bank. Now that was true then. I doubt if it has changed anything under the 1996 Act. The intention was good. The intention was that let us have arbitral dispute resolution as an alternative dispute resolution so that things can be sorted out here without having to go abroad. Now, unfortunately, I do not know whether you want me to focus on the Arbitration Act as a whole or the amendments. I assume that you are more interested in the impact of the amendment. So I'll keep my remarks confined to the amendment, because what was wrong with the original act has continued to remain there. I need not talk about it. As far as the amendments are concerned, some of them are good. Take, for example, the amendment which dealt with interlocutory relief granted by an arbitrator. Now, there was no provision in the act, original parent act, by which it could be enforced. So if, as an arbitrator, I granted an injunction, the party against whom it was granted could thumb his nose at me and say, do what you like, I'm not going to implement this. Now, fortunately, that has been changed, and the arbitrators order of interlocutory injunction or interlocutory order of any kind granting interim relief is now treated as much as an order of a court. Section 9 of the Act deals with powers of the court. Section 17 deals with the powers of the arbitrator. But there is an amendment introduced saying that whatever order is made by the arbitrator shall be enforceable under the provisions of the Civil Procedure Code as if it's an order of the court. One good point. The other good point is, when you had an arbitration, the arbitrator did not have power of granting any relief, interim relief, other than what was specified. So, as a judge, I would have appointed a liquidator to take, a receiver to take charge. I would have appointed a third party to do some investigation, maybe E&Y, or somebody else to do something, some valuation. Now, these were doubtful cases. The arbitrators were hemmed in by the language of the Act, which said that you could direct an order only against a party to the dispute. Now, obviously, that doesn't include a third party who is not concerned with it. So, fortunately, that lacuna has been removed and a wider power given to the arbitrator now under the Act as amended, almost the same as a civil court could have granted, including powers of appointing receivers and so on. Where is the lacuna in the amendment? The amendment has made some impractical suggestions, impractical provisions of law actually, not even suggestions. What is that? The award has to be rendered within a period of 12 months. Looks very nice. Intention is to ensure that arbitration is carried on expeditiously in the country. But how does it work in practice? 12 months from which point of time? 12 months from the point of time when the arbitrator is notified or the last of the arbitrators is notified in case of a multi-paneled arbitral panel, tribunal. What happens in practice is this, that you notify the tribunal today. Today is the 30th of August 2015. So the law says the award should be rendered on or before 30th of August 2017. I can assure you from my own practical experience that no party is ever ready with the pleadings that are necessary. Nobody will ever file the statement of case on the first day. They will ask for 4 weeks adjournments or 6 weeks time to file it, and then another extension of 4 weeks. So the opposite side says, I am also entitled to 8 weeks of time to file my own pleadings, and then the rejoinders, and then wrangle about what are the material issues that need to be discussed, what are the witnesses to be examined in support, again time for asking for filing affidavits in lieu of examination, or what they call the witness statements in foreign arbitrations. Now all this takes away more than 6 months of time. Thereafter then come a series of problems. Lawyers are not available because they are busy in something or the other. Witness is not in, he is sick or he is traveling abroad or whatever the other reasons. And even if everybody is available, the arbitrator himself may not be available because he may have other issues. So as a result of which, there is very little likelihood of the award being rendered within 12 months. Consequence. Speaking for myself, I have said this amendment was brought into effect from 24th of October 2015, after which I said I am not going to do any domestic arbitration. because I'm not prepared to give an undertaking to the court that I'll finish in 12 months when I know as an honest person that it's not possible. Now, how does it happen that abroad they do it? I do a lot of these international commercial arbitrations seated outside. I can tell you, recent experience, of course, in SIAC last year, the same thing happened. 5 days, Monday to Friday. Fixed 1 year in advance. All interlocutory things done on email, because obviously 3 arbitrators from 3 different countries cannot meet every now and then. Final rendering of evidence and submissions is fixed on a particular date, which is agreeable to all the persons. Taking into consideration Christmas or this or that, whatever it is. Then finally, from Monday to Friday, so many days allotted for evidence, so many days allotted submission by one party, so many days by another party. Matter is closed. Thereafter, within the period stipulated by the institution, you have to render the award. That happens. Why does it happen? It happens, A, because you take a long view of what can be done. Fix the program much in advance, so that nobody can say, oh, I was caught, my witness was not available, nothing of the sort. And once it is fixed, it is in place and nobody alters it. Now, as a judge, I have seen what happens in this country. As an arbitrator, I am seeing it every day. Now what happens? Now as an arbitrator, the law says, if somebody doesn't turn up, even the amendment says that, if they doesn't turn up, shut the whole thing. Close the proceedings. Don't allow him a further opportunity for filing pleadings. And the judge agreeing with me. If I did that, the reaction of the judge who entertains a petition under section 34 is, oh, heavens would not have fallen if you had granted him another adjournment. This liberal attitude is really killing arbitration law in this country. I was concerned with a SIAC arbitration. I will tell you an interesting anecdote. Now, we had given them time from this date to this date, 2 days for submission by one counsel, another 2 days for reply, and another 1 day for rejoinder. The counsel did not turn up during the whole. We waited for giving him a grace time of 15 minutes, after which we said, go ahead with the matter. If the counsel is not there, we are going to meet. Then we finished the matter and then rendered an award. That award was challenged on the ground, oh, I was not given an opportunity to make my presentation. I'm told, I was not present, but I'm told that the Singapore High Court just gave him 1.5 minutes, after which he threw him out and said, you were given the time, you didn't appear, the panel is correct, the tribunal is absolutely justified. I am an optimist, and I'm hoping someday I will hear that from our own High Court or other High Courts in the country, saying that you were given the time, you didn't turn up, so good luck to you. If that happens, I can assure you every arbitration tribunal will be able to satisfy, why 12 months, you can do it in 6 months. Now, if you don't change the mindset of the litigants, if you don't change the mindset of the lawyers, and mindset of the lawyers, that's something I didn't dwell upon. For the first time, I was asked to work as an arbitrator in Delhi, and I went to Delhi. I'm used to Bombay work culture. There the lawyers said, sir, we can't do arbitration every day from 10:30 or 11 o'clock. We shall do it only from 5 o'clock to 7 o'clock. I said, on my dead body. Last working hours I had as a judge of the Supreme Court was from 10:30 to 4. And I refused to work earlier before that or even later than 4 o'clock. Now, if this can be inculcated, that this is an alternative dispute mechanism. Namely, this is in lieu of the court. This is not a secondary adjunct of court work, that you finish your court work and then do it when you have time as a hobby, either on after 5 o'clock in the evening or on holidays. This attitude must change. If the lawyers change their mindset, if the litigants change their mindset, if the judges change their mindset, the amendment is good. The law is possible to do it. In fact, I had an occasion to meet the Chief Justice of India just about 10 days ago. He had invited me because he was bothered about this issue. What was the reason why these sudden amendments were? Actually, the amendments are not sudden. The amendments have been coming at least, I know, at least for 2-3 years. Several symposia were held. The Law Commission was asked to look into it. The Law Commission looked into it and came out with some practical suggestions. But unfortunately, those suggestions have not been rendered into the Act. Those suggestions have been tampered with some bureaucrat somewhere along the line without understanding the implication of this. So if that is the attitude of the bureaucrats, namely that they can tamper with something that a law commission comprising all persons who are well versed in law and who are well experienced in law, then the no legislation will be able to stand the test of scrutiny. There is another provision. What is it that you need to do? You need to have an impartial arbitrator. Now, how do you test impartiality? By looking at the background. And if you look at the background, there is something that happens. For example, I must tell you another personal experience of mine. I was, rightly or wrongly, perhaps even wrongly, one of the most popular counsel when I was practicing in the High Court. There was not a single employer in this country who was not briefed me in some matter or the other. So when I became a judge, so I asked my Justice Bharucha, who was former Chief Justice of India, was my senior judge in the High Court. So I said, shall I recuse myself from this? He said, knowing your background, if you start recusing, there will be no work in the High Court that you will be able to do. So that is the attitude. But unfortunately, the amendment made where you have to give a declaration to the High Court that you have the time enough to finish the arbitral award within 12 months. And you have to give a disclosure of what are the persons who had talked to you about in the last 3 years. I never keep such track of record, and it's impossible for me to do it. Then, do you have any social meetings with I have meetings with you all. I've shook hands with a large number of people here. If any of you is involved in arbitration, I'll have to recuse myself if you strictly apply the law as it stands. Now, these are the disclosures to be made. And then there is a schedule of fees which by any count is ridiculous according to me. Now, if all this happens, what is the result? The result I have seen, I said I will not do a single domestic arbitration, and a number of my colleagues have refused to do a single arbitration. The impact on the litigating public is, they'll say we don't want to get into it because at the end of 12 months, the disastrous provision of law is the mandate of the arbitral tribunal vanishes unless an extension is agreed to for another 6 months, and which dishonest respondent who wants to litigate will agree to that kind of an extension. If he does not, then you go and stand in the court and then wait your turn and hope the court will extend it by another 6 months or more. There are several provisions in the amendment which say that the High Court shall dispose it off within a period of 60 days. I do not know how many of you have had the opportunity of moving in the corridors of High Court or appearing in the courts. Such provisions are galore in several statutory enactments, and not one of them has ever been satisfactorily complied with by the High Court or any court in this country. This test will fail surely. If the High Courts can dispose of extension of, first of all, the High Court was not able to handle nomination of arbitrators for 5 years, which is a simple application. All that you need is, do you agree, you don't agree, I appoint the arbitrator. That is all it is. But I am told that in the Bombay High Court, such applications were pending for 5 years. Now, we can imagine the time that is taken to dispose of all these items of business. That is another aspect of the matter. Namely, that we are long on legislation, but we are short in implementation. Now, if implementation is not done, there is no way you can take it out of the purview of delays, the purview of what is happening in the country. In fact, I was mentioning it to you, the Chief Justice was worried that the result of in fact, the Chief Justice started by telling me the amendments are good. Why? Because all foreigners will now insist that India should be an arbitral seat. I said, dear Chief, I'm sorry, my practical experience shows that the result is exactly the converse. Now, if I have to do an arbitration in Paris or in London or Singapore or Hong Kong, I'm not bound by this. Nobody tells me that at the end of 12 months, your mandate will vanish. Yes, people look at their calendar and settle the calendar in such a manner that even if it is a long period of time before all this happens, thereafter things are taken from day to day and finished. They also know that if the arbitral award is to be challenged in a foreign jurisdiction, the result is 99% negative. Nobody succeeds unless there is some extraordinary flaw. Whereas here, I think practically all petitions are admitted by the High Courts. Now, this is the mindset that needs to be changed. And unless that is changed, you are not going to have foreigners running into India to have India as an arbitral seat. Perhaps it's too soon to say, though I have found in experience it has been happening, that people would say that I would rather do it in SIAC or I would do it in ICC abroad, either in Hong Kong or in Paris. Now, what did we achieve? The amendment was intended to do exactly the converse. But what has happened is an unintended result. Now, these are some of the pitfalls of the new amendments, and it is not an easy thing. As I said, intention was good. The intention was that there should be expeditious disposal of matters. Is it happening on the ground level? I do not see anything. Anyway, 12 months have really not expired from 24th of or 23rd of October 2015. Like you all, I am also waiting with bated breath to see how many arbitral tribunals can finish their awards before that deadline, and how many of them will have their mandates nullified by the provision of law, and how many will thereafter have to go and stand in the corridors of the High Court waiting their turn. And another ridiculous thing that I found, which is really offensive to me, at least considering that I was a judge of the Supreme Court of India formerly. If there is a dispute as to whether the timeline has been followed or not, the court is empowered to apportion blame and say, is the tribunal responsible for it? Is the party responsible for it, or the other party responsible for it? Now, what happens in a situation like this? Each one will throw the blame on the other. Now, probably both of them will throw the blame on the arbitrator, which means the arbitrator has to appear before the court and justify himself, show that these are the circumstances. I think that's a ridiculous way of looking at it. If you are going to subject an arbitrator like me, who was a former judge, to this kind of indignity, I'd rather keep away from that. Yes, Arbitration Act does not require any qualifications. Anybody can be appointed. Good luck to whoever hears the matter. So these are some of the pitfalls with the unintendedly I don't know who decides these things when parliamentary committees should decide it. There should be a debate in parliament. I don't know how many of you have read any debate in parliament. I have not seen it. These are some of the things which ought to have been debated threadbare. Each section should be subjected to a debate. But unfortunately, the parliament today is very busy with other important matters, and they have no time for this. If at all, they have time for sessions in the parliament. Now, this is the result of a very half-baked legislation, which, in my own estimate, is going to create more problems than it will solve the problems. Anything else that you want me to say on that?
Just to take your point further, I think the one of the reasons the mindset is not changing is because there's just too much of frivolous litigation, and there's just no major costs or penalties provided in the law. And that's probably where India lacks as compared to any of the Western countries.
You're
because
right.
I think
that is also correct. I must accept that one of the good things this amendment does is enhances the power of the court and the tribunal to impose realistic costs. Unlike our civil procedure code, where some maximum 2,000 rupees. Therefore, if I were to say, I'll impose a cost of 50 lakhs of rupees, some response is there. Then you challenge it under 34, the judge will say, put on the table your 50 lakhs plus whatever your award against you, plus a provision for cost. The man will hesitate and say, aisa hai to nahi karna hai, hum ghar jayenge. That is the way of changing the mindset, but then today the mindset is still the mindset.
Justice Srikrishna, my concern was in relation to day-to-day proceedings and evidence being heard on a day-to-day basis. So you gave us an example of the SIAC arbitrations, and I have seen this in arbitration seated abroad, where Monday to Friday, for example, for a 5-day hearing would be set aside and everybody would meet and an adjournment would be unthinkable. Do you think that this is realistic given the amendments to the Arbitration Act, which suggest that day-to-day hearings should be conducted, but we don't have a separate arbitration bar, as you've said?
Exactly the point.
If counsel are in court through the day, is this realistic?
It's not going to be realistic, because this is one of the grounds that I always emphasize. Abroad, The lawyer says, whether I appear in the court or appear in arbitration proceedings, my fees are not going to make any difference to me. So he says, fine, today I'll appear in the court, tomorrow I'll do an arbitration for 5 days and earn his fees. Or there is a dedicated bar which takes only arbitration and deals with it. That is not there. Counsel, that's why I said this is treated as some kind of a hobby. If I have nothing else to do, I'll come for arbitration. That is another mindset which has to change. Now, how does it happen abroad? Because there is a dedicated bar, or even if it is not a dedicated bar, the lawyers are prepared to come and do it before the arbitral tribunal because they don't think that it is some infra dig for them. And the arbitrators coming from 3 different jurisdictions, maybe across the world, have no time to spare for all this again and again. All of them say, sit here and dispose of the matters. So things do not change drastically unless you change it from the ground level. That is the crux of what I am saying. Law is good. Implementation is better.
Now take a case where there's a shareholders agreement where there's an arbitration clause.
Yes.
But there's a case which is coming into like oppression and mismanagement under 397, 398 of the old Act.
Yes.
What is supreme? The CLB, which is now of course the NCLT,
CLB
or the arbitral tribunal?
See, the 2 jurisdictions are totally different. Any number of CLB judgments are there. Even the Supreme Court has said it. The CLB is concerned only with 397, 398, what are the 400, whatever the other section. Oppression, mismanagement, consequential remedies. He is not concerned with a breach of the contractual provision. That is none of his business. And by any time, lawyers are very clever. You can't dispute that. Apologies, ma'am. They will try to pass off a breach of a contract as a shareholders agreement. Thank you.
Thank you, Arpinder, and thank you, Justice Srikrishna, for an incredibly informative discussion about the recent amendments to the Indian Arbitration Act. I'm going to be speaking about exiting joint venture agreements and private equity investments and breaches of contract. What is termination? Termination is the expiry of a contract, either at the end of its term or being brought to an early end. I am going to be focusing on bringing contracts to an early end during this presentation. Termination is not undo a contract as if it never existed. Instead, it excuses parties from further performance of the contract. Some obligations survive termination, for example, the duty of confidentiality or the liability to pay damages for breaches committed during the lifetime of the contract. Common reasons for terminating a contract include breach of a clause in the contract. This could be a material breach or persistent breaches. Change of control of a party. So if one party is acquired by, let's say, a competitor of the other party will want to terminate the contract. Damage to reputation. A party might want to reserve its right to end the contract if the other party's conduct is going to damage its reputation. Insolvency and convenience. So sometimes it's just convenient because it becomes uneconomic to continue with the contract. And if this is the case, parties have the right to terminate contracts in accordance with the termination provisions set out within the contract. This seminar focuses on different types of termination. So you can terminate a contract in accordance with the provisions set out within the contract. You can also terminate using what are called common law remedies. This will be under repudiatory breach of contract or rescission. I will first explain repudiatory breach of contract and rescission, and then go on to explain termination under the contract. There is an English law focus in this presentation, but the concepts of repudiatory breach of contract and rescission are well ingrained within the Indian context as well, and so these concepts can be applicable to domestic Indian arbitrations or litigation. Now, repudiatory breach of contract. What is repudiatory breach of contract? It is a breach that deprives the aggrieved party substantially of all of the benefit under a contract. So, a party who abandons the contract is in repudiatory breach of the contract. In doing this, the party would refuse all further performance under the contract. It may not necessarily be through words or in writing. It can also be by conduct or implied. For example, if A has entered into an agreement to buy certain raw materials from B on a regular monthly basis, and B performs its contract and supplies the material for a few months before declaring that it is unwilling to continue its obligations under the contract because, for example, B might have found another buyer who is willing to pay a higher price. So B decides just to stop sending any raw materials to A. B is then in repudiatory breach of the contract, and A can terminate the contract on the basis that B has abandoned the contract. In the reverse, so if A decides to stop paying money to B for the goods that it is receiving, the delay doesn't necessarily become repudiatory breach of the contract unless there is an intention that has been demonstrated by A, which occurs together with other evidence, in which A suggests that it is absolutely not going to pay and is abandoning its obligations under the contract. A party cannot take advantage of its own wrong in this case. So, for example, if B decides to stop sending raw materials to A, it cannot take advantage of its own of its own wrongdoing and terminate the contract if A then says, "Oh, you have stopped paying and stopped supplying materials, and therefore I will stop paying." A repudiatory breach can be cured, so it is important to act promptly. For example, if in this contract, B stops sending the materials to A, and A is twiddling its thumbs and is taking its time to get legal advice or is deciding what it wants to do, in the meantime, B has the deal that B was hoping to get with this other buyer who was going to pay more than A has fallen through, and suddenly it starts sending the materials to A once again. In this case, the breach has been cured. If A has not sent a notice to terminate the contract, A has lost its chance to terminate the contract. In this situation, it is wise, therefore, to reserve one's rights to terminate the contract. So if A would have sent a notice to B to say, "We realize that you are no longer going to perform your obligations under the contract, but we are reserving our rights to terminate the contract," that is a good way to preserve one's position so that the breach cannot be cured. It is important to know that whether there is repudiatory breach of contract is judged at the time of termination and not when the contract was made or when the breach was committed. One must take action to terminate the contract. So there are two alternatives. One, to accept the repudiation and bring a contract to an end by serving a notice of termination. And the second is to affirm. So one can continue the contract. It's not necessary that A would want to put an end to the contract. It can continue the contract and sue for specific performance. Generally speaking, a contract will not say that a party is allowed to terminate on the basis of repudiatory breach of contract or rescission. That doesn't mean that you don't have the right to do this. Even if a contract is silent about these two, you would have rights under what is called common law to bring the contract to an end under both of these concepts. Repudiation is possible and bringing the contract to an end is possible only when there are reciprocal provisions. So, for example, it is difficult to imagine one party in a group saying, "I'm going to terminate the contract," because another party in the same group is in repudiatory breach of contract. That would not make sense. Rescission is technically not termination. So, rescission is the act of voiding a contract as if it had never existed. The contract is set aside entirely and the parties are put back into the position that they were in before the contract was made. This means that both parties would have to return whatever they have gained under the contract. For example, if A purchases the entire shareholding of a target company from B, A would have conducted due diligence and made several inquiries about the company that it is buying. And B, in turn, would have made representations and warranties in response to A's inquiries. If, during these representations and warranties, B made certain representations that were false, so therefore it is guilty of misrepresentation, then A can say when it discovers a misrepresentation, I want to rescind the contract entirely, which means I want to actually go back into the position that I was in before I even entered into this contract. Whether that is possible and whether the parties can be restored to the original position is a discussion I will come to later. If I can give you another example, if A contracts to purchase machinery from B, and A realizes that the representations that B had made in relation to the machinery, so supposing B had said this machine is going to produce 10 tables an hour, but actually it turns out that the machine only produces 1 table an hour. So that's a misrepresentation on the part of B. A can say, I resigned the contract, here take your machine and let me have my money back. But the important thing is, here take your machine. The machine has to be returned for A to be able to get the money back. And therefore, the parties will go back to the position that they were in when they had not entered into the contract. So this distinguishes rescission from termination of a contract. Because in termination of a contract, the future obligations of both parties are curtailed. But they are not released from obligations that would have already occurred at the time of termination. In the case of rescission, the contract is set aside as if it never existed. When does the right to rescind arise? So there are 4 scenarios mainly: misrepresentation, undue influence, coercion, or fraud. And these are the cases when one can rescind a contract. The right to rescind can be lost. It can be lost, for example, if one of the parties affirms the contract. So as soon as misrepresentation is discovered, the party who is aggrieved must elect to either rescind or affirm the contract. If the party affirms the contract and continues its obligations under the contract, the right to rescind is lost. Affirmation may be implied by conduct. So, for example, in the case of the machinery, if A continues to use the machine and continues to produce the tables, then it has affirmed the contract and it cannot rescind the contract. However, affirmation requires knowledge. So if A is in a position where A is not aware of this misrepresentation that B has made, then acts done in ignorance cannot amount to affirmation of the contract. But not doing anything for too long also is an act of affirmation. So if the table has been if the machine has been producing just 1 table instead of 10 for 2 years, it cannot be claimed at the end of 2 years, oh, I've only discovered the misrepresentation just now. And this brings me to the next topic, the next point, where the right to rescind can be lost, which is the lapse of time. So undue delay in bringing a claim is a reason or is an issue which loses one's right to rescind the contract. In the case of fraudulent misrepresentation, as opposed to innocent or negligent misrepresentation, the time starts running from the discovery of the misrepresentation. However, in innocent or negligent misrepresentation, time begins to run from the conclusion of the contract. One must also bear in mind what kind of contract they have. So, for example, if it's a contract for the sale of shares in a volatile market, it's going to be hard to, if the shares have been sold on, to put parties back into the original position, and so one must act fast. However, if it's a contract that is complex and requires a greater amount of time for consideration, where it is no longer possible for the parties to be restored to their pre-contractual position, that is another reason that can do away with your right to rescind a contract. And also where a bona fide third party has acquired rights under the contract. Partial rescission is not allowed. An entire contract has to be rescinded. One, if you are not the aggrieved party and actually you are the party who has committed the misrepresentation, then one must think at the time of entering into the contract whether it is worth putting in an entire agreement clause. So this is a clause which would say that this agreement represents all of the understanding between the parties, and any other discussions or negotiations of heads of terms which would have been signed do not form a part of this contract. By doing this, you're limiting your liability to be faced with a suit for rescission for misrepresentation. So I move on to contractual termination. We've discussed repudiatory breach of contract, and we have also discussed rescission. The third is terminating a contract under the clauses provided for within the contract. So this would involve following the procedure set out in the contract. For example, a contract might say, a 30-day notice might need to be given to the other side to cure the breach, and at the end of those 30 days, another notice might need to be sent to say, we now terminate the contract. And this procedure must be followed in order to be successful for contractual termination. But a party serving notice must comply strictly. A non-compliant notice might have no effect. Minor defects may not always invalidate the notice. A reasonable recipient who knew the background to the case. Relevant provisions could appear anywhere in the contract, but they tend to be in the notices clause or in the termination clause. I would suggest documenting the termination. So when trouble starts to brew, it is prudent to gather supporting evidence. For example, document the grounds of termination clearly. If you have given a chance to the other side to cure their breach, document that. Keep all records of communication, whether they are electronic or in hard copy. This includes WhatsApp messages, SMSs, and so on. And also minutes of telecons, which provide crucial evidence sometimes in a case. And take legal advice if you need to take legal advice. It is not necessary to just put without prejudice on all of your communication. Sometimes it can be tactical not to do that. I have seen in a recent case where the notice of termination itself was a without prejudice communication, which threw the entire termination up in the air. Once again, this is something that I've mentioned earlier. There is no duty of good faith if you're allowed to terminate a contract in accordance with its own termination provisions. So, if the contract says that you are entitled to give a certain number of days notice and terminate, you are allowed to do that. You do not have to act in good faith, and you do not have to think or be sympathetic to the other side, unless your contract actually says that both parties must act with mutual cooperation. Losing the right to terminate. Now, to keep the contract alive, that is called affirmation. We've spoken about this earlier already. And this can be implied by conduct. Now, if a party, for example, in the case of the machines, decides to keep the machine, coming to know about the misrepresentation, the parties are stopped from terminating the contract. This is because that party has led the other to believe that it will not terminate, and it would be unfair to allow that party to go back on its word, and the party has therefore lost its right to terminate the contract. There is also, again, in this situation, a possibility to reserve your rights in relation to termination after becoming aware of the breach of contract. Now, sometimes it also happens that a party thinks that it has the right to terminate, but actually does not have the right to terminate. And terminating without the right to do so is a big risk. And it can amount to repudiatory breach of the contract, and then the party who is terminating allegedly for a breach but doesn't have the right to do so will be faced with a suit can be faced with a suit for repudiatory breach of contract. Notices in general must be sent in writing. Now, does email constitute writing? In the case of England, I would say yes, email constitutes writing, but there are jurisdictions that are more formal around the world, and India is a formal jurisdiction. And therefore, I would suggest sending the notice of termination by in the contractual procedure, in accordance with the contractual procedure, as well as by email, especially if it is likely to come to notice of the other side more quickly by email. So send both if you have to. Practical steps after serving a non-compliant notice. So supposing you do have the right to terminate and you've sent the notice, but it's procedurally incorrect, you've forgotten to put something that was required by the contract to be included within the notice. What does one do? Try again, so serve the notice again, following the correct contractual procedure in this case. You can also defend the first notice. So when you send the second notice, you can reserve the right to argue that the first notice was valid, because sometimes the timing can be crucial. You can also argue that the receiving party is stopped from relying on the non-compliance because through conduct that receiving party has waived its own right. This is quite relevant and important for parties who wish to continue with the contract. You can renegotiate and attempt to vary the contract. While doing that, you can decide whether the previous contract is going to be novated, so the new contract is an entirely new contract, or if it's just a variation of the previous contract. Sometimes threats to terminate also work because it brings the other party to the negotiating table. Now, having explained repudiatory breach of contract, rescission, and contractual termination, how does one decide between these three? I think this is best done through a discussion of various examples. So, in one of the cases where I was recently instructed, I was representing an Indian pharmaceutical company against a German research and development company. The Indian company had instructed or engaged the German company to manufacture a coating for catheters for the heart. The German company was unable to manufacture this coating and stopped all of its activities. The Indian company therefore said, "You've stopped your activities, so I'm not going to make my payments that were due under the regular installments anymore." And in turn, it was faced with an action for repudiatory breach of contract. Now, had the Indian company continued to make its payments that were due until it served a notice for repudiatory breach on behalf of the German company, it could have saved itself from being served with a notice of termination. In another example, an Indian company borrowed a US dollar $45 million loan, which was very common in the pre-Lehman Brothers era, and was able to repay 10 million, was not able to repay the remaining. This was a syndicated loan, and one of the defenses was that the Indian company was missold an interest rate swap. Again, this was the flavor of the season a few months ago. The lawyers in this room will share my sort of the fun that we've had with the interest rate swaps and the mis-selling of interest rate swaps. Anyway, so one of the defenses was that the Indian company was missold the interest rate swap. Now, if we would have claimed this, and if we would have claimed misrepresentation, and if we would have rescinded the contract, rescission puts parties back to their original position, which would mean that the Indian company would have to repay all of the money that it had borrowed. So it was an impossibility to plead that. But a way out of it was to plead fraudulent misrepresentation rather than negligent misrepresentation. Of course, proving fraud is an extremely high threshold, so one has to consider their options quite carefully before deciding how to plead termination of a contract. So I would suggest consider your options carefully. In the event of termination, remember that the aggrieved party is entitled to be put in the position as if the contract had been performed. In the case of rescission, an aggrieved party is entitled to be put into the position as if the contract had not been performed. Take action. So some positive action is generally required to terminate, such as the sending of a notice. And do the following. Assess your legal grounds. So assess termination versus rescission. Consider the practical difficulties that you would have. Comply with all procedural requirements for termination, and document the grounds and the process of termination. Remember that you have a choice. You don't have to only follow the termination procedure set out in your contract. You can also, as I've said earlier, serve notice under repudiatory breach of contract or rescission, even if your contract is silent about it. Now, if you're affirming the contract, new rights to agreed payments will continue to arise. Sometimes the right to continuing payments, if you are receiving the payments, is more convenient and valuable rather than terminating the contract. So think about not terminating the contract as well. There are a couple of situations when one cannot affirm the contract. So one cannot affirm the contract when damages can be an adequate remedy, and where it is wholly unreasonable or perhaps it's perverse to insist on specific performance of a contract. This brings me on to damages that follow as a result of termination of the contract. I will only touch upon them because damages is a topic that can, cover a couple of lectures in itself. Damages are a compensation for the loss suffered. They should put the aggrieved party back into the position it would have occupied had there been no breach. Now, if you're the party who has had the good bargain under the contract, so if you have paid some, less than market value for something, then the aggrieved party would prefer to sue for damages for a breach of contract, and this would give him the lost profit on the deal. However, if you're the party who had the bad bargain in the joint venture or the private equity transaction, you might want to consider rescission, and this would give you the difference between the value of the contract and the value you would have had if the representation had been true. In the case of a breach of contract, you will need to prove that the contract exists, that the term was breached, damages were suffered, that the damages was directly as a cause of activities done by the other side, and those activities were not so remote that these damages could not have arisen from that. In the case of rescission, you will have to prove that the misrepresentation was made, it was false, and that you entered into the contract relying upon that misrepresentation. So this brings me to considerations when drafting joint venture agreements. Address the key issues in your agreements. So define an event of default. Common events of default are material or persistent breaches of joint venture agreements, change in control of the other party, an attempted transfer of a party's interest to another entity, or the insolvency. Now think about when you're drafting the contract, in what circumstances would you wish to terminate for the other party's breach? Consider defining a breach as a failure to meet a performance measure X times over the course of X days, for example. Think about if you're a supplier, does the supplier require a right to terminate for a customer's failure to pay? When will the delay in payment be considered to be a material breach of the contract? What change in circumstances would make a customer or the supplier entitled to terminate the contract? For example, if the volume of the goods and services are not as expected, or if there's a change in economic conditions. Discuss all of this with the lawyers who are drafting your contract to be able to put all of these into your events of default. Now, if an event of default occurs, then also you can make the following provision. So you can terminate and seek damages, but you can also invoke something called the put or call mechanism. For example, an innocent party might be able to sell its shares to the defaulting party at a premium. This is called a put mechanism. Or acquire the shares of the defaulting party as a default, and this is the call mechanism. Now, be careful about the amount of discount or the amount of premium, because this can, if it is too vast or if it's completely out of proportion to normal economic activity, it can be termed as a penalty, and penal clauses are unenforceable in India. The law in relation to penalties has changed considerably in the United Kingdom after a recent Supreme Court judgment. And if in cases of commercial transactions which have been entered into at arm's length, where both parties have had legal representation. So it's not, for example, an insurance company against, let's say, a widow next door. It's not an unequal bargain, but two commercial parties who would have negotiated a contract. And if they would have put in extreme provisions of discount or a premium, they will be upheld, especially if they are contained within the contract and are not a secondary obligation. Now, post-termination. Also think about, we've discussed the events of default and putting events of default into the contract. Think about what you would like after the contract has been terminated. So how will intellectual property be unbundled? How will confidential information continue to be protected? Who will be entitled to any future income arising out of the joint venture's activities? And who will be responsible for any continuing liabilities? How will the customer base be divided up? And so on. Lastly, drafting dispute resolution clauses. This is a complaint that I make to most of my friends who are corporate lawyers and who draft the agreements, because this is the last clause that seems to be just thought about for 5 minutes and just thrown into the agreement. But it can have severe repercussions if the joint venture or the shareholder agreement goes into a dispute. So consider carefully whether you would like to arbitrate or litigate. We have had the benefit of Justice Srikrishna's talk on arbitration and the pros and cons. So, consider very carefully whether you want to arbitrate or litigate. Do you really need the confidentiality that an arbitration provides? If you don't, would you be better to be in court? Think about various other mechanisms, such as saying, for example, if you are, in an international transaction, that the English court has jurisdiction rather than an arbitration seated in London or an arbitration seated in India. Think about appeals. So, for example, again, we've had the benefit of Justice Srikrishna's discussion on appeals and, how an arbitration is just adding six years to the 24 years already before the Indian courts. But think about the reverse. So, for example, if you were in an arbitration seated abroad, the appeal mechanism would be very strict, and very, very few appeals from an arbitration award are actually entertained by courts abroad. If you are considering arbitration, think about whether you need a single arbitrator or 3 arbitrators. Don't just throw in 3 arbitrators because it seems like a sensible thing to do. Because 3 arbitrators would mean increased costs, and matching diaries of 3 arbitrators can also be quite difficult. Think about what law you would like. Would you need Indian law to apply, English law, Sudanese law, etc. Think also about the substance of the contract and the governing law of the contract versus the procedural law of the contract. So, for example, you can have an arbitration seated in London where Indian law applies, and the procedure would be an institutional procedure such as the ICC or the LCIA. On the reverse, you can have an arbitration seated in Mumbai where, for example, Qatari law applies, and the procedure is governed by the new Mumbai Center for International Arbitration. So in an arbitration, you have great flexibility to choose your options. So please use that choice carefully. In summary, even the best relationship will have problems from time to time. So look for win-win solutions to problems rather than trying to score points off each other. Identify all the possible grounds for termination, weigh up their consequences together with your legal advisors, and weigh up their chances of success. And then be strategic in your termination of the contract. Choose the one that is most favorable, and if there is a doubt, then consider, but not necessarily do, consider asserting all your rights in the alternative. This is again just a summary of termination versus rescission. In the case of termination, a contract is not undone as if it had never been made. The contract still has a legal effect, and instead, from the time of termination, both parties are released from any further duty to perform their primary obligations under the contract. When a contract is rescinded, it is undone entirely as if it had never been made, and both parties are restored to their pre-contractual positions. Thank you.
My name is Sagar Kadura. I work with Nation Desai Associates. What are your thoughts on having a seat in India for a proposed arbitration now with the new law?
The new amendment allows you to decide whether you want your interim, whether you want the arbitration to be governed and you want the courts in India to have interim measures or not. So, for example, in an arbitration, and especially in India, quite often an interim application becomes relevant because you need immediate reliefs and you cannot wait to have the award of the arbitration passed. Before the amendment, because of BALCO, so the Kaiser aluminium matter, it had stopped Indian courts from interfering with foreign-seated arbitrations. This is now a choice under the new amendment. So this is a useful provision to have when deciding the seat, because it now no longer matters whether the seat should be here or abroad. Previously, I would have advised have the seat abroad, because then the Indian courts will not interfere. But now you can have a seat of arbitration in India, and you can choose that the Indian courts will not interfere with an interim application. So that is one thing. The second thing, however, is the appeal mechanism. So decide which law governs your procedure, because the law that governs the procedure in an arbitration also governs the appeal mechanism. So if you are in India and Indian law applies as the procedure, then you're opening yourself up to appeals in the Indian courts. However, if you have Indian law that applies to a foreign seated arbitration, then the appeal procedure will be whatever is applicable under that particular institution.
Thank you so much. Thanks a lot.